Distinguished ladies and gentlemen, my name is Olufemi Elias, and I am the candidate of the Federal Republic of Nigeria for election to the International Court of Justice for the term 2021 to 2030. I have devoted my entire professional life to public international law. Decades ago, following my PhD on an aspect of the sources of public international law, I began my career in academia, teaching public international law before moving on to work in international organizations. I am currently the Registrar of the International Residual Mechanism for Criminal Tribunals, which is the institution mandated to complete the essential tasks of the International Criminal Tribunal for Yugoslavia and the International Criminal Tribunal for Rwanda. I've worked for over 2 decades in the UN system. I served, for example, as the legal advisor and the director of the legal office at the Organization for the Prohibition of Chemical Weapons, the OPCW, in The Hague. The overwhelming majority of my time in the international civil service has been working in judicial and quasi-judicial institutions, commencing as the legal officer, legal advisor in the Governing Council Secretariat at the United Nations Compensation Commission, and eventually serving as special assistant to the executive secretary of that same commission. I subsequently, later in my career, became the executive secretary of the World Bank's Administrative Tribunal, and now, in my current position, I'm the registrar of a criminal tribunal. I have also served as a judge for staff appeals at the United Nations-backed Special Tribunal for Lebanon in The Hague. Now, in all these positions, I have gained invaluable experience in the practice of dispute settlement in an international context. I have issued legal decisions and judgments, always carefully balancing the interests of the parties, while always being mindful of the cohesion, coherence, and development of the existing body of case law and jurisprudence. Also, in these positions, which has always involved the interpretation and application of treaty regimes and dealing with diverse and often complex legal issues in interstate relations, I have always keenly followed the academic and analytical discourse on public international law, and I've continued both teaching and publishing in the field. Now, in addition to publishing extensively on the law of treaties, customary international law, other aspects of the sources of international law, on international law as it relates to international organizations, on the law of international organizations, and specifically the law of international courts and tribunals, on international environmental law, on the law of disarmament and arms control, my publications have also spanned boundary disputes and issues of state immunity and aspects of international human rights law, all of which are subjects that have fallen for consideration by the International Court of Justice. It has been a great honor that the organ tasked with the codification and progressive development of international law, namely the United Nations International Law Commission, has made reference to my publications in several of its reports on the various topics on the Commission's agenda. It has also been a singular honor for me to have been elected to the Institut de Droit International, whose membership includes several past and present judges of the International Court of Justice. The International Court of Justice is the only international court vested with general subject matter jurisdiction, and this is reflected in the variety of matters with which the court has been seized since it was established. Indeed, in the past 25 years, the court has been seized with more contentious cases than in the first 50 years of its existence. Now, one explanation for this sustained increase is what has been referred to as the transformation of the International Court of Justice into a world court. Distinguished ladies and gentlemen, given the court's general subject matter jurisdiction, it is crucial, in my view, that the candidates, as required by the language of the statute of the court, be jurisconsults of recognized competence in international law. For me, this means broadest possible background in all aspects of international law and international relations. I believe I fall into this category, and indeed I pride myself on being a generalist in international law. It would therefore be the biggest honor for me to have the opportunity to bring my experience and expertise to the service of the court, today's true world court, and to contribute as much as I can to its noble and challenging task. I thank you.